But here we are, and we are saying that it is possible. This is the same jurisdiction whereby we are saying child marriage is illegal. Child marriage illegal. Remember, a child is a child until they're 18 in Kenya. And we're also saying that children should be in school and should be doing things constitutionally that a child should do. Can we play in the same space when we have already established some of those things? We've said child marriage is illegal because they've not reached the age of maturity. But something as intricate and as serious as sexual consent, we can leave to the whims of an adolescent from 13 until 19, when we are saying that a child is not, when a human is not starting to embrace maturity properly until 25, and we're also in the same jurisdiction refusing things like child marriage for the same reasons that we are saying that you can actually have consensual sex. How do those things play in the same pool? That debate really needs to be, and it's a very intricate debate, I would say. Because, you talk about what the psychologists have said. There are also others, biologists, saying that you have your metabolical age, and there's your age. So there are issues here. But I would say that if we have to make decisions touching on age and when you're allowed to make a decision, we need to have clarity. I dare say some 40-year-olds don't even know what they're doing, but okay, conversation for another day. Yeah, we need to have clarity, and we need to avoid internal contradictions, because you can't, as you said, you asked if this child can consent to another child, why shouldn't they consent to an adult? So those are very serious questions to ask, and they need to be answered. And the way to answer them is, let's have a legal reform, at least on the issue in the area of criminal law. Remember, previously, people were allowed. 15-year-olds would get married, 15 years plus, before these law reforms came in with the Children's Act and the Marriage Act. Before then, people would marry at the age of 15. There was a reason why we moved away from the 15, because there were children who were being married off, and they were basically they were not going through the education system. So education was being put in jeopardy. They were getting into marriage when they cannot even understand what they're doing. They are too young to decide at that time. That's what we were told. Now suddenly we are told, they're allowed. There's been advancement. So that's what I'm saying. There's a lot of contradiction. We need to have clarity in our legal system. If we moved away from from child marriages, now suddenly we are telling them you can engage. Because actually in this case that was before the court, both the first and second petitioner actually got into cohabitation with the girls in question. Yes. They both got into cohabitation. So you see, there were actually bigger issues, which when I read the judgment, the court seems not to have gotten into understanding actually what the full picture. Like, for instance, for the second petitioner, apparently at the time he was arrested, it was as a result of some domestic disagreement with the girl. The girl is a third petitioner. Yeah. But the court, I do not know if it was disclosed to the court, but in this judgment, we are not told what was this domestic disagreement. Was it an aspect of gender violence, which now led this boy being arrested and now being found to have been cohabiting with a child? She is 17 and the girl is 16. Yes. So you can see the court lost sight of the issues. And that's why I think we can all agree here today that we need a national conversation. We need a law reform that goes for the full picture. Yeah.
Because the full picture for me as well is you are 16, promised to marry someone, and this person is just waiting for 8:30 a.m. for you to get married. At that particular point, is this a child? Is this an adult? And if you are turning 18 and still in school and you're removed from school, then what happens to the Constitution in offering you the right to education? I mean, there's a lot of conversation that needs to be held, that we cannot just leave it at the decision that has been made by the court. We can't just leave it for the reforms that need to happen in the legalese space, but everyone has to be included in that, because it touches on education, it touches on human rights as well, and rights of everyone who wants to have sex as well. So my question then is, with a parliament that clearly has not picked this up, perhaps now from your space, how do we move forward with this matter?
So as I said, this issue
requires, indeed, I think, I've been thinking about it for a little while. I think this decision must be what it becomes our reawakening. That we're in a legal system, particularly the criminal justice system, which is in a state of pandemonium. Decisions are coming from different courts that do not, that lack harmony. So I would say what the starting point would be, let's go back to the judicial decisions that have been passed. There is Muruatetu case.
Okay.
There is this one. There are many others that came from Muruatetu where courts are saying a life sentence is 15 years.
Yep.
So then now we're even interpreting life sentence. Because life sentence means life. You're taken in for life.
Yeah.
Now suddenly courts are saying life sentence means 15 years, means 25 years.
Yeah.
And that's someone who killed another person. So this is the time we need to review all these court decisions. And it doesn't have to come from the parliament. It doesn't have to come from the judiciary. It can be me and you and other Kenyans out there who feel angry enough to sit down and get this work started.
Would you reckon we're angry enough?
I think we are very angry as a nation from many things. And maybe that kind of it kind of kills our focus because you are worried about the economy, the governance. I think Parliament has become very irresponsible. They are not really legislating. The role of Parliament is to legislate, oversight, those kind of things. They are not doing those things. They are cheerleading as opposed to they are cheerleading for the executive. Because I've looked at Parliament sometimes doing things with some magical efficiency. Remember when we had the impeachment of Rigathi Gachagua?
Yeah.
It was done, the speed, how the new deputy president, who is now being called a deputy in name only, was elected through Parliament within, the magical speeds. We can employ the same level of efficiency to reform this law. It means that we can do it, just that people are not willing enough. But it can start with you and me.
So some of the things, just hear from different groups that we